Hello everyone, welcome to yet another day in this The Clown Decade, the decade where things are only going to get worse before they get better. And if you want to keep up to date with all things Clown Decade, please do subscribe to the channel and of course become a channel member. And today we are once again talking about how, to be honest with you, it's a subject I'm unfortunately getting quite apathetic about because, well, as you'll see, jury trials to be scrapped except for alleged rapists and killers. David Lammy is proposing that judges hear cases alone for crimes that could result in a sentence of up to 5 years to tackle court backlog. So I understand there's a big court backlog. I, along with a lot of other people, want to see criminals in jail for the appropriate amount of time. Sentencing, however, seems to be very lax. And to be frank with you, I think with reforms that have been made to jury trials and the criminal justice system in general, getting rid of jury trials I just cannot get hyped up for like I would with other subjects. Because to be honest with you, I've been quite black-pilled on the whole jury trial in Britain and, well, we will go through why. Because they aren't quite what they used to be. Effectively, this is like the House of Lords. I like the House of Lords. I think it's good to have a second chamber. However, the problem is that the Lords as it currently stands has been so vandalised, it won't make much difference if you get rid of it. Honestly, it's the same with jury trials. So juries will decide only murder, rape and manslaughter cases under a shake-up of the legal system which could signal the beginning of the end for trial by jury. The majority of cases will be heard by a judge alone except for the most serious or those deemed to be in the public interest. In a memo seen by The Times, David Lammy, the Deputy Prime Minister and Justice Secretary, wrote to other ministers and senior civil servants in an all-government department this month to say that there was no right to jury trials in the UK. Ugh. And that drastic action was needed to cut the backlog of cases in Crown Courts in England and Wales. Okay, I take back what I said before. This needs to be stopped with every lever of power that the opposition can grab. Because David Lammy saying there's no right to jury trials in the UK is absolutely wild. If this was more of this is just a temporary measure to cut down the backlog, I'd think, alright, fair enough. I get that a lot of people probably would prefer a trial by jury, but we'll just go with judges for now to cut down the backlog. But no, David Lammy's gone a step further and said there's no right to jury trials. This tells me that by 2029 we could see the end of jury trials at all, which isn't what I want. I want jury trials to effectively have the reforms stripped back, and we'll go through some of those reforms because some of them are crazy and have ended up with people who can't even understand English on jury benches. But yes, we'll get into the problems of all that. Lammy's decision to create a new tier of court in which serious criminal offences will be tried by judges alone goes well beyond the recommendation of Sir Brian Leveson, who was commissioned to review the criminal courts and report it in July. And this is just the Labour government through and through, just complete and utter mavericks. What in the manifesto suggested that we would have major changes to the courts in this way? What did we have to suggest? That we'd have abortion till term? What suggested that we would have the assisted suicide bill? Nothing. And I suppose, to be absolutely fair, when it comes to the assisted suicide bill, that's a private member's bill and has gone to a free vote. But just to counter that, it's also a major change to the way the country is going to work. Obviously, you're going to have to vote for a mandate on that, but it's been given a free vote, and Westminster is full of liberal progressives, so what do you expect? Of course they want Canadian healthcare. This move, however, will require primary legislation, which is planned for early next year. Leveson, a former Court of Appeal judge, has been asked to propose ways of reducing the backlog of Crown Court cases. His main recommendation was the creation of an intermediate court in which a judge would sit with two lay magistrates. The recommendation came after the Times Crime and Justice Commission also proposed the introduction of an intermediate court with a judge and two magistrates, which is suggested would speed up justice and reduce court delays. Again, this is why I'm not completely against the idea of temporary measures like this to reduce the backlog, because ultimately I prefer to see criminals in jail or at least punished than free on the streets. And the reason this is better than just a single judge is because you have two lay magistrates who effectively can give second opinions to the judge. Lammy's note to Whitehall indicated that the government was going to remove the lay element from the trials involving many serious offences, so it's just one judge instead. This is a highly controversial move. Senior criminal justice figures have already described the plans as the biggest assault on our system of liberty in 800 years, and suggested it would lead to Star Chamber justice. The Star Chamber, which sat between the 15th and 17th century and comprised judges hearing cases alone, had become synonymous with arbitrary and even secretive rulings. and I'm on board with these issues. Ultimately, judges have made horrible decisions in the past. We've seen plenty who have let people in or remain in the country when they obviously shouldn't have been. There's been plenty of slaps on the wrist when there should have been life in jail. And this is where the two lay magistrates are supposed to help out with not having it as the arbitrary rule of a judge. But this is where I come into my problem. My first real blackpilling experience of jury trials came after the Colston 4 were acquitted by a jury trial. Protesters cannot rely on human rights defence's top judge rules. Acquittal of 4 who toppled statue unchanged, but appeal court decision could affect future trials for significant criminal damage. I've done videos on this before, but effectively what happened with the Colston 4 is that there was a jury. Obviously you don't know who's on the jury, and why would you? But we do know that the defence brought in effectively people like Kahindi Andrews and other black studies professors and people who professionalise in that sort of grievance study, and effectively made the argument to the jury that the Colston statue just being there was an affront to effectively locals' comfortability in the city of Bristol, and therefore it wasn't a crime to actually topple it, because effectively what did end up being public property damage, which it was, even though they were acquitted for it, ultimately it's been for the greater good of the community. And that's what got the jury trial to acquit, which I just found insane, because I don't know why that argument will have flown, but this was Bristol after all. And this is when I started to realise maybe jury trials aren't necessarily the best in every case. But then you look at judges' decisions and you think maybe the whole justice system needs a complete restart. So protesters accused of significant criminal damage cannot rely on human rights protection when on trial, even though they did. The ruling comes after the Attorney General made a referral of a point of law following the acquittal of the Colston 4. Shiela Burrowes, who is now Home Secretary, made the referral after Tory MPs criticised the acquittal of protesters who toppled the Bristol statue of the slave trader Edward Colston. Hang on now, philanthropist Edward Colston, let's not forget what he was mostly known for. A range of defences were used in the case. Court of Appeal was asked to consider one that argued the conviction for damage to the statue would have been disproportionate interference with the defendant's right to protest under the ECHR. Juries have unqualified right to acquit, and the highest court's decision does not affect the outcome of the Colston case, but it does mean defendants in similar cases will not in future be able to rely on the Convention's right to freedom of thought, expression and assembly. So I suppose at least they overturned that, but obviously the appeal court can't make that decision and then overturn the decision of the jury. Ultimately, the jury made a really bad decision, and that is being upheld. Again, this is my original blackpilling when it came to jury trials, and I can understand after that why Lee Kuan Yew actually got rid of jury trials when he was initially making reforms in Singapore, simply because there was, well, a multicultural issue where certain demographics were letting off their own demographics due to natural in-group preferences, I suppose we'll say. And frankly, the same thing's happening here, though it's obviously we don't know the makeup of the trial, of the jury, sorry, so it could also be the out-group preference problem too. But ultimately, I do just want to make the point that when a jury decision is so bad, you have literal QCs, because they were QCs at the time, literally going to Twitter to say, wow, jury trials need a look at, because this decision is so awful that we literally cannot rely on jury trials to give us justice anymore. That's when I start agreeing with them and thinking, yeah, jury trials have a bit of a problem here. But the problem goes back a bit more, and Stakeholder Consultant has an awful lot of examples that we are going to go through on Twitter. So jury selection was abolished in England after lawyers defending ethnic minorities began objecting to white jurors to ensure acquittals. So before 1988, again, this is how long ago this was, the opportunity to challenge preemptorily occurred after the clerk had asked 12 members of the jury panel to step into the jury box. Defence counsel or the accused, if underrepresented, would call out challenge immediately before the juror in question took the oath. No reason needed to be given for the challenge, and the juror was replaced by another. The right of the defence to challenge jurors had been steadily eroded over time. In 1925, the number of challenges was reduced from 25 to 12, and in 1949 the number was further reduced to 7, or 7 per defendant, where several were tried together. In 77, the number was fixed at 3, and in 88, the Criminal Justice Act removed the right altogether. These progressive reductions appear to have been precipitated by concerns arising in particular cases. The 77 restriction followed a case in which a number of youths, mainly black, were tried for causing criminal damage and disorder. Oh. The thing with it, I was about to make a comparison with the Colston 4, but all 4 of the Colston 4 were white, so it doesn't quite work. The defence, then again, they were doing it in the name of black people in the city of Bristol, I suppose. The defence used their preemptory challenge to try and achieve a representation of ethnic minorities in the jury, and the youths were acquitted. So yeah, there's been lawyers being lawyers for over a century in Britain, and it appears that, well, they ruined it in 1977. This goes back nearly 50 years, this problem. And for another trial, the lawyers defending a ring of homosexual spies in the armed forces used the challenge to ensure a young male jury. Prior to the most recent change, concern arose when multiple defendants pooled their challenges in single trials, and one trial in particular, the Cyprus Secrets case, fueled the campaign for the abolition of preemptory challenges. When 8 men in the Royal Air Force were charged of offences under the Official Secrets Act, it was claimed that the council had privately agreed to exercise their preemptory challenges to ensure a young male jury. The defendants were all acquitted, but it is questionable whether this was because of the composition of the jury. Either way, they certainly tried to get a more favourable jury of this. And this voir dire was further restricted after a judge agreed to exclude from the jury anyone with relatives in the police, armed forces, or any member of the Tory party. The right to ask questions of prospective jurors was severely restricted after the so-called Agu Brigade trial in 72, which involved charges arising from, amongst other things, bombing of the houses of the members of Parliament. The trial judge agreed to ask jurors to exclude themselves on a number of grounds, including if they had relatives serving in Northern Ireland or in the police force, or if they were a member of the Tory party. 39 jurors were removed after questioning. Shortly after the case, the Lord Chief Justice issued a practice note designed to stop such questions. In 73, the Lord Chancellor decided that jurors' occupations would no longer be available because of evidence of abuse by defence counsel, who were using information when exercising preemptory challenges in cases with political overtones. Basically, total and utter corruption in the system has ruined the chance to take out people who are on jury trial and who are likely to be prejudiced in cases, because defence solicitors and, of course, judges were abusing these powers. I mean, to me, it's quite mad to exclude anyone who is a member of the Tory party when someone is standing trial for, bombing members of Parliament who will have been in the Tory party. Anyway, stakeholder consultant goes on to say that the juries of 2025 are not the juries of yesteryear, and until the 70s, all jurors were property owners or heads of households, and until the 90s, they were almost all have been exclusively British citizens. Yes, you heard that right. After the 90s, people who weren't British citizens could be considered British peers on jury benches. So from the 70s, the juryman in the eyes of the law is the epitome of the reasonable man, the man in the street, or to take it from a well-known judgment, a phrase that has now become archaic, the man in the Clapham omnibus. But it is an odd thing that you stopped several men in the street or held them up in Clapham omnibus while you interrogated the passengers. You'd very likely find that only a few of them were qualified to serve as jurors. At common law, the qualification was that the juror should be a freeman, not a villain or an alien, but from the earliest times statute have imposed a property qualification as well. A man of property was thought less likely to be corruptible and more easily punishable by fine. I think that's definitely true. The qualifications in force at present were settled in 1825 and have remained the same ever since. Notwithstanding that in the 130 years that have passed, England has changed from an oligarchy in which the ordinary man had little say in the affairs of the country into a democracy in which every man and woman has a vote. A juryman must still be either a property owner or a householder. If he owns freehold property, it must be of annual value of £10 or more, and if leasehold property, must be on the lease for not less than 21 years, and of the annual value of £20 or more. Remember when property cost tens of pounds? This is probably going back to the 1800s, to be fair. If he is a householder, he must reside in property of an annual value of not less than £30 in London and Middlesex and £20 elsewhere, or in a house containing not less than 15 windows. These all feel very arbitrary, I have to say. But, it worked. These figures, which were doubtless significant in 1825 and no longer of much importance, they may be compared to those which were at the upper limits for the purpose of the Rents Act, namely £100 in London and £75 elsewhere. There may be a few country cottages which have an annual value of less than £20, but at least since the recent revaluation, which came into force in April 1956, there can't be many properties below that annual figure. The real factor, therefore, restricting the jury franchise is not the exclusion of any appreciable number of property owners and householders, but the exclusion of all citizens who are not householders, and that means the majority of the adult population. In other words, back when we were in the golden age of the jury, I suppose, it was because you had a limited pot of people you could actually pick from, and absolutely all of them had to be a somewhat successful either homeowner or head of household. The man who, let's say, has an interest in keeping law and order, as it will help him keep law and order in his own household due to limited externalities of criminals being able to get in because they'll be in jail. And in fact, Stakeholder Consultant makes the point that since the reforms, you don't even have to be a British citizen to sit on the jury or vote, hence the phenomenon of jurors who struggle to understand English sitting on trials, and the example here is a juror of a trial of a man accused of causing death by dangerous driving was discharged because she had difficulty understanding English. A spokeswoman for the government agency which oversees the administration of courts said there would be no investigation into the issue after the judge got rid of her because she couldn't understand English, as it acted in accordance with protocol. So at least we can still have some challenges that make sense, rather than having no reason whatsoever. And in fact, he goes on to make the point that jurors were also age limited to under 60, and the exclusion of many specific persons kept a lot of the upper classes out. The jury is not really representative of the nation as a whole. It's predominantly male, middle-aged, middle-minded, and middle class, i.e. the very person who has an interest in keeping the country's law and order in check. Never seen more than 4 women on a jury, and you are almost as likely to find none as 3. 2 is the most common number, and 1 is quite usual. The property qualification is one of 2 factors that tend to make the jury middle class, the other being the exceptions. Low though it is, the qualification must have the effect of excluding some of the working class, while the exemptions cover a large section of the upper and upper middle classes. The loss of ability resulting from the exclusion of so many professional men and women is especially severe. It is the property qualification again that helps to determine the middle age of the jury, since young men are less likely to be householders. The upper limit of 60, settled at a time when the average age of the adult population was much lower than it is today, excludes many men and women of vigorous intelligence. And again, it's not to say that this was a perfect system. You could probably up that age now to 65, 70, something like that, or maybe exclude pensioners, given that's 64, I believe. And I mean, at this point, it feels almost revolutionary to say only property-owning people can do X, Y, Z in Britain. The funny part of that is that we've never had a time where more people own property than before. So you are still including more people than ever before in history if you put you need a freeholding property to be a juror, meaning that it's obviously still quite representative of the population. But anyway, so disqualification is now very limited, and anyway, a person disqualified is liable to serve if his name is included in the juror's book. The chief exemption appears members of parliament, county and town councillors, lawyers, clergymen, medical men of all sorts, including dentists, chemists, and veterinary surgeons, soldiers and sailors, policemen, and post office servants. That is not a comprehensive list, but it's sufficient to show that the exemptions are wide enough to affect quite considerably the character of the jury. Which is the funny part of all this. Part of the whole revolution of the juries was to make juries more fair, but they still get rid of people that it just so happens the left hate. The weird one, though, being doctors, chemists, dentists, and vets. But, well, hey, there we go. Maybe there's good reason for all that. I'm going to Chesterton's fence this and say, I'm not sure why these exemptions exist. I guess members of parliament make sense, and peers also, but the rest of them I don't really get. But, well, there's been a revolution in the juries, and that's why I'm not as mad as a lot of other people. However, ignoring the recommendation to have a lay magistrate seems to be the worst part of this. Another revolution we've had over the past century is that until 1940, jurors in murder trials were basically under house arrest for their duration. So until 1940, the old practice still prevailed in capital cases. That is to say, the jury was segregated through the whole trial from the moment they went into the box and took the oath until they were discharged. They had board and lodging at the expense of the county and were under the charge of the jury bailiff, whose duty it was to see that no one communicated with them, and they were not allowed to have newspapers. Many a housewife must have been startled by the call of a policeman asking for a case of her husband's night things, for the course of the name of any juryman who served on the trial was not known until he was called to the box. Under war conditions, the rule was relaxed, and the relaxation has since been made permanent. The jury may now be permitted to separate at any time before they consider their verdict. Again, this all makes sense because you're in a trial, you are there to hear the evidence, and you can't have your view painted by outside sources. And newspapers are obviously going to be reporting on murder cases, which can colour one's view on what's going on within the court. In fact, in the Victorian era, the jurors were denied food, drink and light to force them to come to a unanimous verdict. One set of Tudor jurors was fined £5 for eating figs and apples during deliberations. Again, I don't think we need to quite go back to this, but I'll leave the details of those stories for you to go through yourself as they're posted on Twitter in Stakeholder Consultant's tweets. He also finds more tidbits about the jury system in Britain. We know about jury nullification, but what about the juries convicting against the judge's orders? So 2 cases illustrate the position under modern law, the first in 1911, and I give you the facts stated in the report. At the close of the case for the prosecution, counsel had submitted to the judge that there was no case to go to the jury. The judge said that probably there was no intention to steal, and that if he were a juryman he would so find, but that the case ought to be left to the jury. Counsel accordingly did not put appellant into the box, and the judge directed the jury in favour of appellant. The jury, however, brought in a verdict of guilty. The judge would not accept the verdict and remarked that he had thought the jury had some common sense. He had thought that they would act in the way that they had. He would not have left the case to them. He then directed the case for the defence to be proceeded with before the same jury and added a few more words of summing up, directing the jury against that no animus Ferrandi had been proved against the appellant. The jury again brought in a verdict of guilty, and this verdict was adopted, but the judge postponed sentence and granted a certificate for appeal. Perhaps the jury was stung by the reference to its common sense, or perhaps mystified by the nature of animus Ferrandi. There appears to have been some evidence of an intent to steal, for the Court of Criminal Appeal said that if the whole case had been before the jury at once, they could not very easily have interfered, but they quashed the conviction on the ground that the trial was unsatisfactory. Basically, this judge annoyed the jury and they just made life difficult for him. That's all that happened in 1911 there, which is, I have to say, very funny. And again, the point of this video isn't to say jury trials aren't good, get rid of them. It's to say there are issues with them. They are not God's gift to the planet of justice. However, getting rid of them completely would be an affront to justice. I do agree with that. And I think Lammy's move to just have a singular judge, where in periods of history we've had that, and it's ended up with completely arbitrary rulings, means that yes, I would actually rather defend this imperfect jury system, and it's even more imperfect now, than have everything be given to judges, even though there are good judges who make good decisions out there, of course. We then come to another case in 1938, to which I referred. The judge was dissatisfied with the verdict of guilty because he felt he had made an error in his summing up, so he refused to accept the verdict and ordered that the accused should be tried again. No doubt he thought he was doing a fair thing by the accused, but in fact he was depriving him of the opportunity of having the conviction quashed on appeal. At the new trial before another judge, the accused pleaded Autrfois convict, sorry if I butchered that Latin, and the plea was upheld, but the judge sentenced him upon the earlier conviction. Mr. Justice Humphreys at the Court of Criminal Appeal described the case as comedy of errors and said, anything more contrary to the law it would be difficult to imagine. No judge has the right to say that he refuses to accept the verdict of a jury because he thinks that he ought to have directed them on the law and has failed to do so. The matter didn't stop there, because the acting chairman proceeded to do what no one in this country has power to do, namely to direct that there should be a new trial. And so, oddly enough, this is a second case where the judge has absolutely ruined the case, had a go at the jury for getting the case wrong, though to be fair he blamed himself, and then effectively perverse the court of justice to some degree to try and get his way. Well, the jury trial said no. Which was true in this case, I have absolutely no idea, but the point of a jury is that they come to an agreement, and whether that actually agrees with the judge or not is, well, not really relevant, as it came to bite the judges in the backside in both these cases. And with that, so that is a quick crash course in the issues of juries even in the past, and the juries we have today are nothing like the juries we had before the 1970s and 1940s. A lot of people would say that they are actually worse, and while it seems that a lot of people do end up in jail who deserve to be in jail both at jury trials and at magistrates, I can't get over the fact that I know there have been jury trials, high-profile ones, that have ended up with absolutely insane outcomes, such as the Colston statue. So I find it hard to plant my flag too hard in this case. However, I think that it would be better to keep jury trials around and reform them to be better than they currently are, rather than doing what David Lammy is doing, which is slowly eroding them out of existence. I'm sure that is an opinion that won't annoy too many people. Right, with that, I think that's everything I had for you for today. So if you enjoy what I do, please do subscribe to the channel and become a channel member, all that good stuff. Like, subscribe, super chat, super thanks. In terms of shilling, tonight there will be more gaming for Deus Ex Human Revolution. Friday there will be a Wolves of Westminster podcast. Videos out as and when I can make them. Right, I think with that, that's everything I had for you for today. So once again, thank you all very much for watching, and until next time, goodbye.